didn't create the businesses that gave us our first start in becoming self-sufficient, or the democracy we were lucky enough to be born into. That was all done by people who came long before we were. And we'll never know who they are, probably. Leave 10 South Sound encourages each person to find the things that resonate in their life and support them in person now, and then leave something behind when they're gone to make the world a little bit better than the way we found it. Leave 10 South Sound is ably run by 26 community volunteers made up of nonprofits, professional advisors, that's attorneys, CPAs, financial planners, trust officers, and of course donors who represent Pierce, Thurston, South Mason, North Lewis, and now Grays Harbor counties. They are an amazing group doing equally amazing work for their communities. So please drop your questions into chat today. Our digital wonderkind, Genevieve Ferrari, will monitor the chat and assist us in getting your questions asked and answered. We will begin with the basic of estate planning, but at about 12:30, we will transition into a panel of professional advisors to help answer your questions. You'll have a great deal of expertise at your disposal for about 25 minutes. We hope you'll take advantage of that. Today, we're excited to have a veteran estate planning attorney, Lauren Pitman, from Pitman, Huff, Raedel, Magaro, Lifetime Legal, PLLC, and that's in Olympia. And Lauren will explain the basics of estate planning in a way that is understandable and up to date. She received her bachelor's from Cornell and graduated with honors from Seattle University Law School. Lauren runs a thriving legal practice in Olympia and has specialized in estate planning for more than 20 years. She is a member of the National Academy of Elder Law Attorneys, a past board member of the Mayday Foundation, and a past executive committee member of the Senior Action Network of Thurston and Lewis counties, and has been president and board member for the Hands-On Children's Museum in Olympia. Well-rounded person. So now, in observance of National Estate Planning Awareness Month, Leave 10 South Sound is proud to feature estate planning attorney, Lauren Pitman. Lauren.
Thank you so much, Rick. I'm really delighted to be here. I feel very honored. I myself personally have worked with my local community foundation to commit to leaving 10 of my estates. So I'm really excited to be part of this program today. I'm going to share my screen here to share with you a presentation that I've prepared. The hope of our presentation today is to have you walk away feeling like estate planning is more accessible, you have a better base understanding so that if you choose to do planning on your own, or you choose to work with an attorney, you feel ready to go armed with knowledge so that you can make some informed decisions. Okay, can everybody see that? People who work for everyone can see it, no problem?
Yes, you're good to go.
Okay, thank you. So I think the first question really that people pause to think about is what really is estate planning? How is it going to help me? Who is it for? What does that mean? And people often think about when they think about estate planning, lofty estates in the countryside, a lot of zeros in the bank account, and that just simply isn't what estate planning is designed to do. It's really intended for everybody to have an opportunity to talk about and put in place their own legacies, their own value systems around their assets, charitable giving, family management, caring about their loved ones, young people, beneficiaries. And so it really is, the planning really is important for everybody to do, no matter what financial circumstances you might be in, what long-term care capacity circumstances you might be in. It's just a critical component of making sure that your own wishes are carried out in a way that you want them to be carried out. It gives you an opportunity to plan not just after you pass away, but also while you're alive, how you'll be treated when you are maybe unable to make your own decisions anymore and facing end of life. Typically, when I use the word estate planning, what I'm really talking about are some estate planning documents. But documents themselves are not the estate plan. Having a will is not having an estate plan. It is having an estate planning document. The planning really comes from thoughtful considerations about what you'd like to see included and how we can carry out your desires and goals. So here are some of the goals that a lot of my clients come to me with that often start conversations And it's important when you arrive, if you're going to work with an attorney, to have a sense of what these are so that your time can be well spent, and we can really focus on structuring your plan to fulfill your goals and desires. So of course, the most common one is your legacy. Your legacy could be your money. Your legacy could be a legacy of giving. It could be a legacy of ensuring and caring for family, friends, loved ones. But what are you trying to pass forward to future generations that you'd like to see reflected in your estate plan? That is very commonly including tax planning. And we do have a lot of conversations in the estate planning world, not just about gift and estate taxes, but about income taxes, capital gains taxes. And we think about all of those things as an effort to try to preserve your estate and the money you've worked for and the assets you've worked for to pass to your family, loved ones, or desired beneficiaries. In addition to just thinking about tax strategies, people like to keep the assets that they've built. So we talk about how may we be able to protect assets from creditors, either future creditors of beneficiaries or perhaps even your own creditors. An incredibly important part of estate planning can be really focused on long-term care planning. How do we ensure that in a married couple, both spouses have access to the resources necessary to pay for their long-term care? How do we make sure that disabled beneficiaries have tools available to them to financially support them beyond any kind of assistance they might be receiving from the state or other services that may be available to them? How do we protect that? What is often overlooked and a really important part of the planning is talking about retirement and financial planning. We talk about sort of what are estate planning documents, and people usually, and I'll go over them, but think about wills and trusts, powers of attorney, advance directives, and they forget that there's this whole other sort of collection of assets that pass in a variety of different ways, including retirement assets. IRAs, 401ks, deferred compensation plans, and those are a really critical part of our planning because poorly executed documents in that world and retirement designations can undermine an otherwise thoughtful plan. In addition, retirement planning and retirement designations are a really valuable tool for any kind of charitable giving we might be looking for. And of course, we're here today to talk about that. And so, of course, that also guides our conversation around charitable trusts, beneficiary designations, and other tools for passing assets at your death and during your lifetime to the charities and organizations you care about. So this process can be really intimidating. My favorite sort of compliment from clients when they walk out of a first appointment with me is, whew, that was so much easier than I thought it was going to be. And I'm so happy to be able to do that. And I think part of why that happens is that we really can help prepare clients before they come in to understand what are we going to do? What's that going to look like? What should you bring in to the meeting to ensure that the time is used to the best of the ability, because we know attorneys and other financial advisors cost money. How do we limit that expense by being prepared? So here are some of the things that I think are really valuable when people come in, and not just if you're meeting with a lawyer, but the own exercise for yourself if you're doing your estate planning on your own or through another process. But you really need to have that sense of the goals we've already talked about, right? What are we trying to accomplish? Because that shapes the whole rest of the conversation. You need to help us understand and define for yourself who are your legal heirs. So that would be the people who would pass away if you did not have an estate plan or a will or a trust in place. So who are your heirs at law? Typically, that is a spouse if you are married, children if you are no longer married. If you do not have children or a spouse, it goes up to your parents. If your parents are no longer alive, it goes down to your siblings and down their legal lines, and it can go one more generation up to grandparents. So we really need to understand who those people are. That's to be distinguished from who you may be choosing to leave assets to. Who are you wanting to benefit under your estate plan, right? We need their information as well. Everybody's circumstances are different in estate planning. That's what makes it really fun for me and for the people who work in this field. So we need to learn that about you. What is important, what may be different in your family or your sort of world that is important for us to consider. Are we a blended family? Do we have adult children? Do we have young children? Do we have large inheritances coming? Or are we trying to plan for preserving assets for the benefit of somebody else? What may be unique to you so that we can have unique documents that are customized to reflect the circumstances in your life? Now, this is the most critical piece of what I need and what you would need to look over if you were doing your own estate planning of what you need to prepare. And I call it the who, what, and how. So you do need to have an understanding, your advisors need to have an understanding of what you own. What is the value of what you own? How is it titled? Is it in your name or someone else's name? Excuse me. Do you have beneficiaries already listed on those assets? What are we talking about when we're talking about managing and implementing a plan for your money and your assets? It's critical if we're going to be talking about tax planning and critical if we're going to be talking about long-term care planning. We need to know if you have any events coming up or have already happened that might impact your estate planning. Really common examples about that are we're about to have a child, or there may be a dissolution, we're about to inherit money, we've given large sums of money away either to individuals or to charitable organizations. That's an important piece for us to understand because it might impact your plan. Finally, if you have thought a little bit about who you might want to name as your fiduciaries, and when I use that word, I'm really talking about the people you name as guardians for minors or disabled children, trustees, agents under powers of attorney, personal representatives. If you have identified who those people are, then that's good to bring a note at the appointment also. But if you haven't, that's okay. We're going to talk a little bit today about how to choose those people, what things are important to consider. And that can be part of the conversation you have with your either financial advisor or attorney or other trusted advisor about who you think would be appropriate for you. So here are the key components. And I will tell you, I was reviewing the questions in advance of that had been submitted in advance of this program today. And there were a lot of common themes about wills and trusts. And so I did add a slide today that I think is going to it's going to prompt me to remember to answer some of those questions. Of course, you'll have an opportunity to ask questions later, but I'm going to try to hit on some of those topics now, try to provide some clarity around that. But for right now, a will is simply a legal document that specifies how your assets and property should be distributed. It's just a direction to the person you've appointed as your executor for how to distribute your assets and who you want to be in charge of things. A trust is really really similar, but is a legal document that tells you the same things. What do you want to do with your assets? What do you want to do with your property? Who you'd like to name as trustee to manage those assets? But it's the legal entity that holds title to your assets. And so in order for a trust to work, assets actually have to be held by the trust. Now, I'll tell you, I was embarrassingly in my third and final year of law school, sitting in what was the top advanced trust and estate class in the program. And I actually raised my hand and said, we've been talking about trusts for 3 years. What is it really? Because we have these lofty sort of ideas about what that is. And of course, there's a legal document. But what it really means is there could be a bank account that we hold title rather in our names, but rather in the name of the trust or in this legal entity we create. Kind of like a corporation or a company where assets can be owned by those corporations. An asset can be owned by a trust. That might look like a bank or investment account. That might look like deeding a property into a trust. But it goes beyond just simply the document. It really is a legal sort of tool to hold title to assets. Then we're going to talk a little bit about powers of attorney. That's the document where you appoint someone to make a healthcare or financial decision for you. a healthcare directive, which gives you the ability to make decisions about your end of life. It's really rooted sort of in the American value systems of autonomy. So if you were in a terminal condition where death were imminent, how would you like to be treated? What would you like regarding your end of life care? And finally, as I mentioned before, an estate plan is only as good as the tools that have been created around it can effectuate it. So it's critical to focus on beneficiary designations, account ownerships, and other strategies for making sure that the really thoughtful plan we created actually is put into place. So here's a little bit of what to expect at the appointment, right? We want to have, again, I keep harping on it, an open and honest discussion of the goals. We want to talk about what your assets are. The attorney is going to share with you an explanation of either tax strategies, long-term care strategies, planning for young children, planning for future inheritances. There should be, the hope is at that appointment, you walk away armed with a whole lot more information about how to accomplish the goals you've set for the documents. And then typically an appointment ends with a discussion about what the next action plan is, how much is this going to cost, what can the client expect from the attorney, and vice versa. So this is a look typically of sort of what a timeline of an estate planning process would be. You'd be preparing for appointments, collecting asset information, talking to your other fiduciaries, talk to your financial planners and your tax accountants, your CPAs, talk to other sort of business owners with whom you may own legal entities. Have had a conversation to be able to come to the table with their perspective, help them to have the information necessary to help you identify your goals. It's lovely when those people choose to join at the attorney appointment. Of course, it doesn't have to happen, but it's very helpful for financial advisors to be a part, or if we're talking about charitable giving, a development officer to be a part of that conversation, to make sure that we are considering all perspectives and you have a full team of people who are looking out for you and your interests. So then you meet with the attorney, you give them some directions for what to draft. You then review those documents, the drafts, once they are sent to you, talk to your other advisors, review them with your financial planners and the organizations that you're choosing to benefit, review them with your family and your friends if that's important to you. But you want to go through and look at those documents with the other people who are important. Then we need to execute the document. We actually need to put it in place. We need to sign the wills. There were some questions about how a will is validly executed, and I'm going to chat about that in a little bit. But there are requirements for the way that it's executed, and we need to make sure that those are actually followed so that your documents are considered valid and enforceable by a court. Then again, I know I keep talking about it, but we have to focus on those account ownerships and beneficiary designations to be able to be sure that we are supporting our plan. And then over time, we need you to sort of keep track. Have you had a major change in your life? Are you hearing rumblings about major tax changes that might be relevant to you? Do you have children who are getting married? What is happening in your life over time that might trigger the need for you to check in with an attorney? It's typically our recommendation, even if there's no major decisions or changes or family status or financial status changes, that you check in with your lawyer maybe every 3 to 5 years to see if there's something on their end that they might know about that might be relevant for you. Okay, this seems to be the hot topic of questions from people that we got in advance, and we're certainly going to talk about it. And I'm going to talk a little bit more about it now that I know how interested people are. I'm always so surprised when people are so interested about estate planning. It makes me happy, but I'm always thinking people are on the other end of a screen falling asleep and not as excited about these things as I am. But so wills are, we've already talked about it, but legal documents that direct how your assets should be distributed, how they should pass, how they should not pass, right? It's your ability to say what you want. And I'll talk a little bit more about what happens if you don't have a plan, but this is really your choice regarding planning opportunities for the things that are important for you. With a will, you own all of the assets, you own title to them. And so when you pass away, any assets that are not governed by a beneficiary designation or other pay on death designation, those are going to pass according to your wills. Trusts, on the other hand, are the legal entities we've spoken about. And they're really, when people are talking about trust, usually they're talking about living trusts. So those exist during your lifetime that you fund while you're alive. And then that trust is used as the mechanism to manage and transfer your assets while you're alive and then again after you pass away. One of the sort of key pieces of a trust, and something that often doesn't come into play, and people have unfortunately undermined the trust, is that the trust actually has to own title to the assets that you are wanting to pass under the trust. So it's not good enough just to have a trust. You have to have your home transferred to the trust, your condo transferred to the trust, your mineral rights or oil rights transferred to the trust, your bank accounts transferred to the trust. Because if the trust doesn't own these assets, then the trust is sort of irrelevant as to your plan, or we have to use a will to get it into the trust. So there are so many misconceptions about wills and trusts. And when I go to these really large conferences, you hear these estate attorneys sort of chuckle to themselves, because if I hear one more time, well, Susie Orman told me I need a trust, well, Dave Ramsey told me I need a trust, it sort of makes me crazy, because that may be true in some states, but in our state, in the state of Washington, trusts are not very powerful. It used to be that if you had a trust in Washington, and this is still true in other states, that the trust will help you avoid a probate process. And by avoiding that probate process, you have a much easier mechanism that transfers ownership of assets. So people think about trusts as being fast, quick, easy, efficient, inexpensive, no delay. And in Washington, that just simply is no longer true. Our trust administration process is nearly identical to our probate administration process. Not perfectly so. We do have to file a will with a court, but all of the notice requirements that we do with probates, where we tell people that a probate has been initiated and that they're entitled to it, that has to happen with a trust now in Washington too. Wills have a 4-month will contest period. So there is, or can be, or maybe even should be, a delay in the distribution of assets as if we're using a will to transfer. But trusts now too have a 4-month contest period. So again, it's the same. It's advisable not to distribute assets until that trust contest period has passed. The nice thing about wills is we don't have to change the ownership of assets when we're preparing. We can continue to hold assets as individuals. Whereas trusts, we do have to fund them. And I will tell you, it's so common that people incorrectly fund their trust that when we do a trust, we always do something called a pour over will. And a pour over will is a document that says, hey, I have this trust, but if I forgot to put an asset into the trust, I want to use this will to do so. And unfortunately, if that happens, then we have to probate the estate under the will to put it into the trust to then do a trust administration, which is really not what the client wanted or not what the individual wanted and what they were exactly trying to avoid. The probate process in Washington is simple. It is not expensive. It is, well, relatively speaking, it is not a complicated process. Your executor does not have to go to the court every step of the way to get permission to take action under your will. If you don't have a will and you are passing away what we call intestate without a will, then the court might be more involved, but if the heirs agree, it's a simple process to sort of not quite kick them out, but involve them less in the duration of the probate. But in many, many states, and the states that give wills a bad rap, the probate process is outrageously expensive. In California, for example, attorneys get a very significant portion of the assets that are held in are passing under a will in a probate process as part of their compensation. That's not true in Washington. So while there is certainly a time and a place for a trust, and I'm really talking about living trusts right now, really in Washington, they're not really appropriate tools, relevant tools, helpful tools. We have a lot of other ways to pass assets that accomplish some of the goals that people used to think trust accomplished. We have options that pass assets immediately with no delay, no complicated administration. And actually, when we have a trust in place, we are unable to, or at least to the extent where we don't have as many options, to be able to use those other tools. So unless you have real property outside of the state of Washington, where we may be trying to avoid property in that state, unless you have a blended family where we're trying to really maintain assets as separate, or some other complication, trusts often in Washington aren't the appropriate tool for clients. So here are some misconceptions. We sort of have already talked about them, but one I really want to hit on is whether there is a difference in what you can do for tax planning in a trust, whether your sort of more complicated planning for beneficiaries can happen in a will or a trust, and whether you can use a professional, because these seem to be things that people commonly believe about the distinction between wills and trusts. So any of the tax planning strategies we use in a trust can also be done in a will. Typically, when we are using trusts or wills to take advantage of tax strategies or creditor strategies, what we're doing is actually creating trusts under the will. So when most people talk about a trust, they're talking about a living trust or something you create when you pass away. In wills, we use something called testamentary trusts, meaning they're created in your last will and testament. But they're the same tools that we use in both of the different legal documents. Both allow you to take advantage of credit shelter exemptions at the state or federal level. Both allow you to take marital elections or other tax elections that might help save an income tax, capital gains tax, and estate taxes. Both allow the creation of a trust, a supplemental care trust or special needs trust for the benefit of a loved one or someone you care about. So truly, any strategy or goal that you have about your planning can be accomplished through the use of either a will or a trust. But again, if one of your goals is simplicity, sort of unlike what people think, we may have more options here in Washington using a will and some of our other powerful pay on death tools. Excuse me, I need to take a quick drink of water. Often people don't want to put the management of their assets and the responsibility either while they're alive or when they pass away in the hands of the people they care about. It's not the worst process in Washington, but there is some administrative work. So you can appoint professional fiduciaries in both a will and a trust. There are people and entities who do that, and so either of those options are available. So I'm going to flesh out some of these questions. These were, when I was reviewing the questions that people had submitted beforehand, there were some really common themes. And so this was a last minute slide that sort of captures, I hope, some of those really repetitive questions that I'd like to answer. Pardon me, I'm fighting a cold here. So I'd like to go through these and see if maybe I can answer some of your questions in advance before we get to the question and answer. It has caused me a little bit to reprioritize how I spend my time, but given that this was sort of really quite heavily hit in the questions, I think that I'd like to be able to answer the questions that you have and focus on that. So many of the questions surrounded who should I choose as my personal representative or trustee? And I think this is a really important question. So let me begin by who you should not choose. You should not choose your oldest child just because they're your oldest child. You should not choose your male child just because they're the male child. What you're really looking for with a personal representative and trustee is some financial acuity, the person who pays the bills in the family, the person who will get things done, will not procrastinate, will not sit around and let timelines pass, the person who will be responsive to the attorney and the transfer of information. It's helpful, but not necessary if that person has a familiarity with your assets before you pass away. It can help make the identification of assets, that process easier, but it's not critical. People often wonder about proximity and whether proximity is critical for these roles. And I think the answer to that is maybe. We serve many, many fiduciaries, many personal representatives and trustees who do not live in the state of Washington. They might come here at an initial, memorial or when someone first passes away, but they don't live here. All of the legal work, of course, can happen electronically or via the mail. And the conversations and communications you're having with asset holders, those can all happen, of course, also from a distance. What can be more difficult is a little bit of the sort of day-to-day work of cleaning out a home, collecting personal property and distributing personal property, selling a home, those types of things. Proximity, at least for a little while, for a short time, is helpful, but not critical. We can find other people to help with that process. But you really want somebody who is honorable and trustworthy and honest and is going to get the job done. That's going to help save your family strife, save them money, and prevent a delay. You can name more than one person in this role. And there's sort of two ways to do that. One way is that you can name two people, either of them acting. So they can share the job. They don't both have to do it together. They don't both have to sign every pieces of paper together. One can do it on the day that works for them and another one. They have equal access to information and equal power. You can also name two people to act together as sort of right? They both must act, this person and this person. But to be honest, that can be administratively burdensome when we need people to sign paperwork, when we need directions to financial institutions, requiring the signature of both people can be a burden. It is I highly do not recommend naming people who do not get along. So clients sometimes say, well, my kids don't talk to each other, but they're just going to have to figure it out. They're going to have to work it out. Yeah. So if they don't talk to each other and they don't work well together in normal life, we should not be asking them to do so in a situation where there is grief involved, money, taxes, because it's really common to see sort of control battles or conflicts when we have people who have never gotten along. Sometimes it's just a good thing to have sort of a head cook in the kitchen. You have a boss. And then there are professional fiduciaries available for any of the roles we're going to be talking about. In powers of attorney, in trustees, in personal representatives, there are professionals available. Those often come in two different categories. One is somebody working for a guardianship company who serves as a guardian for people in their healthcare and financial decision making. Excuse me. And then they, as an extension of that practice, serve as professional fiduciaries when they're appointed in documents as opposed to when there are no documents in place. There are then the class of large financial institutions who will have large trust companies for those who have assets in some of the big major custodians and brokerages. It's quite likely that they will have trust department who'd be willing to serve as a personal representative or trustee. And then we have people who are smaller sort of businesses who serve as professional fiduciaries, typically focused on financial roles, right? So not healthcare decision maker, but personal representative, trustee, maybe even a decision maker for financial affairs under a power of attorney. So a lot of questions about what the probate process looks like. So the probate process after someone losing my, excuse me, I need to, excuse me, excuse me, I'm so sorry. The probate process in Washington, pretty simple. We appoint the personal representative to act. Excuse me, I need to pause myself just for a moment as I cough. Excuse me, just for a moment. I'm so sorry about that. I'm not sure if it's allergies or getting over being sick, but in the probate process, you submit pleadings to the court to have the court adjudicate that the will is the last and final will. It is the court that issues something called letters testamentary, where you are given, the personal representative is actually given legal authority to act. So a will is not enough. A will is simply a nomination of the person serving as the personal representative, but the court actually has to give legal validity. Then you have to give notice to those people benefiting under your will and those people benefiting who would be benefiting if you didn't have a will. The same is true for trust, but we have to give notice to basically those people who are interested parties. They have a 4-month will contest period or trust contest period if we're using a trust. At the conclusion of that, then we begin to distribute assets. The most common delay of an estate administration is because you have somebody who has passed away at the beginning of the year, and therefore we have to do their taxes at the end of the year, right? So we don't get year-end tax statements until January, February. So if you pass away in February, we have to wait for the end of the year to do your final tax returns. If, however, you pass away in September, it's much faster to be able to do that right away and get that tax work done, those income tax returns filed during the 4-month contest period. In order, if you aren't doing a probate and you have a will, but a probate isn't necessary, then what we do is we have to file the will with the court. So some people ask questions about, do we file a will before someone passes away? The answer to that is no. We don't want to do that because one of the ways that you can revoke a will is to destroy it. But after someone passes away, whether we do a probate or not, we do want to file it with the local superior court. In order for a will to be valid, it has to be witnessed by 2 individuals. It is not a sort of deal breaker if they're interested parties. There's a presumption that we have to prove that they did not act in that interest. We have to show that they are not being influenced by that. So we prefer to have non-interested parties. Those could be neighbors, those could be friends, those could be staff at a attorney's office. Typically not people who are either giving you care or likely to inherit from you. And then we actually have to have a notary, but what's a common misconception is that notary isn't for the testator, it's not for the person doing the will, it's actually for the witnesses. So there was a question here about, we went to a bank and they wouldn't notarize us because they didn't want to determine capacity. Well, actually, they're not determining the capacity of the person whose will it is. They are simply saying that the witnesses signed the document in their presence. Another question that's often asked is what assets are in your taxable estate versus your probate estate? This is commonly misunderstood. In your taxable estate, you have basically everything you owned up to the moment you passed away. So that includes retirement accounts, that includes life insurance policies. What is taxed at the state and federal level is every single thing you have, versus what might be passing under your will. So those assets without a beneficiary designation, which are your probate assets. Some questions about whether you should have a will if you have a beneficiary designation. So beneficiary designations or transfer on death designations direct an institution, a financial institution, to pass assets automatically. My answer is yes, I think you still need a will. Sometimes we find things out there. I just found $130,000 in unclaimed property for an estate. That's a fun surprise. And we needed a will to transfer that. I think I've hit pretty hard on the difference between trusts and wills, and talking a little bit about how you have a living trust created while you're alive, a testamentary trust created in your last will and testament. A lot of conversations and questions on special needs trusts and supplemental care trusts, and I don't have a lot of time to talk about them. But basically, these are trusts that you create for someone who is receiving typically some state benefit, whether it's a Medicaid benefit or food stamps or Section 8 housing, EBT cards, whatever it might be. We can create trusts to hold assets for those people's benefits. They can't manage them. Someone else has to manage it for them. But those assets are not included in a determination of financial eligibility for needs-based programs. So it provides a way to not only ensure that we get we preserve those benefits, that we continue to provide financial support for those individuals, but it also allows us to have someone to help manage those assets. It cannot be the individual beneficiary in a supplemental care trust or special needs trust. Those are basically synonyms. It cannot be that person. Interestingly, if we're doing long-term care planning for spouses and we're creating a supplemental care trust, that can only be created in a will. That cannot be created in a living trust. And finally, how do we incorporate some tax planning when we're considering these things? So someone mentioned that there is no longer a step up in basis and trust. That's not true. That depends on what kind of trust we're talking about. In the context of tax planning, we ensure that we're taking marital elections to be able to get basis step ups, both at the first death and the second death. We think about income taxes. We think about capital gains taxes, because often planning people want to do in the context of capital gains is, in estate planning, is actually going to create a capital gains tax that has a greater impact, creates a larger tax consequence. So we use trust, we use lifetime giving, we of course use charitable giving, we might create some entities, some irrevocable life insurance trusts, a lot of different options when we're talking about incorporating tax planning in the documents. Oh, that doesn't like that Okay, so here are different ways that property is owned and transferred. So separate property is something that you basically have 100% ownership and control over. You can sell it, you can give it away, you can leave it in your estate. There are no restrictions. That is to be distinguished from community property. So if you are married, or if you are in a registered domestic partnership, or maybe even what we call an intimate committed relationship, you may have some what we call quasi-community property that shares the same characteristics and rules of community property. So with community property, you can give away your own share. You can sell your own share. You cannot sell all of it without a joint action between both partners. You can leave your half to whomever you want to. It does not need to go to your spouse or your partner. It can go to your children. It can go to your friends. It can go to a charitable entity. I will tell you, for retirement accounts, they are often governed, depending on what kind they are, under federal law. And that federal law, ERISA, does require a spouse to sign off on a distribution of a 401k or retirement account falling under the ERISA plan. But by statute, you can do whatever you want with your half. I'm going to skip tenants in common just for a moment and go to joint tenants with right of survivorship. So joint tenancy with right of survivorship is a really powerful tool. It allows us to hold accounts with joint names, and it directs that if one of us dies, it automatically goes to the survivor. So it eases the administration process, right? It's really easy. You can wipe out an account or something that's held as a joint tenant with right of survivorship, but you can't close an account without the action of both owners. But joint tenancies with right of survivorships often mess up our estate plan. They are often considered or created without consideration for how it's going to impact a will or your trust. So a very, very common circumstance is that someone has come in and they have an estate plan that leaves their assets to, let's say, 3 of their favorite friends, but they co-own an account together. And they co-own it, they added someone's name because they wanted to ensure that they had immediate access to assets both while they're alive and when they pass away. But the problem with that is that person has a right of survivorship. So when the owner dies, it's going to go to the other co-owner. You will disinherit those beneficiaries that are named in your other estate planning documents. And that beneficiary, that now sole owner, can choose to share it with those people, which might have a gift tax consequence for them, but we can't force them to. So it's far better to use powers of attorney to give authority and access to accounts while we're alive. Probates and trust administrations can happen very, very quickly. People are not without money for very long. So this is a powerful, good tool, but sometimes foils our plan. The alternative to that is tenants in common, where you each own half, where people may co-own properties, but they each own half. Real property is a really common example of this, even between a husband and wife. We may own a home together and we own it as husbands and wife. We each have a tenant in common interest. There is not that automatic inheritance that you see with the joint tenants with right of survivorship. So these tools can really help support our plan or sort of undermine and break our plan. We've talked about some of these different options for transferring of assets. We certainly talked about wills or trusts. We've talked about beneficiaries and pay on death designations. Community property laws are really commonly misunderstood. So community property laws say that everything we've acquired while we are married is equally owned by both parties. And it was originally put in place for spouses who were staying at home while another spouse was earning money. And so we wanted to give an ownership interest to the person staying home. But it is an ownership right. It is not an inheritance right. The statute, however, does let spouses enter into a contract called a community property agreement that does allow for the automatic transfer of assets between spouses. Now, this tool is only going to work if assets are held in individual names. So this is an example of a tool that is automatic transfer, easy transfer option, quick, fast, cheap, but we can't use when we're using a trust. Obviously, making gifts during lifetime is a powerful tool for the transfer of assets. It's typically a critical component of tax planning. It can backfire if we're looking at long-term care planning. We do have some annual gift exemptions of what is currently in this year, $18,000 a year. If you go over that number, you do have to tell the IRS reported on a Form 709. That amount over the exemption is going to reduce your federal and estate tax exemption, which is currently about 13.6 million. So it doesn't actually create a tax to give more than that exemption amount unless your estate is over that dollar number. It just creates a reporting requirement. Finally, a really powerful tool in Washington is a transfer on death deed. So this is basically a beneficiary designation on a house or piece of real property. So you enter into a deed while you're alive that says, when I pass away, or in the case of co-owners, when we pass away, this real property is going to pass to this person. It only runs with the property. So if you buy a new house, then it doesn't carry over. You would have to do it again on that house. But it does avoid the need for a probate or a trust administration because it is yet one of those other automatic transfer tools. Not if it's in a trust, but if it's in your individual name. So that deed is recorded. It must be recorded while the owner is alive. And then after they pass away, the beneficiary can simply record a death certificate in the county and the house automatically transfers. Some things to think about is if you name all of your children, for example, now they are going to own that home together. They have to agree when to sell it, how much to sell it for. And so for some families, that's great. For other families, that creates some concerns. So what happens if you don't plan, if you don't think about these things? Well, sort of like Rick mentioned before, what's going to happen is that intestate statutes are now going to govern your distribution. They're going to say what happens to your assets. Typically, as we mentioned, it goes down lineal lines to children and grandchildren, spouses, of course, also, and then it goes up to parents and down those lineal lines. For some families, that works. For others, it doesn't work. You may encounter tax consequences, issues with out-of-state property. If you don't do any planning, we may wind up having to probate in some of those states where that process is really, really difficult and challenging. And those could be avoided with a proper plan. You don't have the ability to choose who's in control of your plan. You don't get to decide who your executor is. Your heirs have to agree to that. You don't get to decide who your agents under power of attorneys might be. And this is really critical because for a power of attorney, if you do not have a healthcare agent named, the statute gives us an order of people who are going to be named. And it's pretty similar to the intestate statute of who gets your money. But there is no backup for financial powers of attorney. So if you do not have a financial power of attorney in place, the only choice for someone to help you is to get a guardianship for your benefit, which is very costly, strips you of some rights, and very time consuming. Of course, there might be a delay in administration because we don't have our affairs in order. We don't know who's going to be doing the work. We have to claim assets that we might have otherwise been able to get under beneficiary designations. You obviously can't plan for young people and disabled individuals, and all of those things together often results in more expense and more cost. So moving away from the at death documents, we also focus on some during life documents, and I just want to keep track of the time. Rick, how much more time do you think I have? About 10 minutes or so? You're muted.
Yeah, 10 minutes, 5 to 10 minutes.
Okay, thank you. So durable powers of attorney for healthcare and financial decisions, those people who can make healthcare and financial decisions for you if you can't. Healthcare directives, living wills that talk about if you pass away, whether you want to be kept alive on life-sustaining treatment or not. Do not resuscitate orders, pulse orders. We now have mental health care directives, dementia directives, all of these things to be dictating who is going to get, excuse me, not fast enough to pause my screen. All of these advanced directives to say what happens to you if you can no longer make decisions on your behalf. Excuse me just for Man, I was hoping to make it through this without having to cough. I'm really sorry about that. So healthcare directives, legal documents, if I'm in a terminal condition and death is imminent, do I want to be kept alive on life-sustaining treatment? Do I want to be kept alive on artificial nutrition, hydration, respiration? Do I want pain medication, right? So if you are in a permanent vegetative state, not if you're up and healthy, do you want to be kept alive on these other means? And it's commonly misconstrued as a do not resuscitate order, which is a very different document. It may speak to whether you want to be resuscitated if you are in a terminal condition where death is imminent. However, the do not resuscitate document really is a PLLC order, a physician's order on life-sustaining treatment. I've shared a picture of it with you here. It is you would know it if you saw it, is on a very ugly green piece of paper. This is a document that's not provided by the lawyer. It is actually provided by your medical provider. It is provided by a doctor who has to sign it. And in my mind, this is for individuals who have a pretty low quality of life, even if they were to be resuscitated at their highest level, and end of life already sort of facing. If you were to be in a grocery store and you have a heart attack right there, if you have a PLLC order, depending on which medic arrives, they may not choose to resuscitate you. They're commonly found in nursing facilities or other care facilities where you have them posted. Then again, our sort of healthcare directives have extended to mental health advanced directives. And then also this new sort of movement about voluntary stop eating and drinking, which is not a do not resuscitate order, but allows you to express your wishes around whether you want to be around food, fed, and given liquids while you are in the dying process. I do want to go back for a moment. I did skip one thing I wanted to talk about with powers of attorney. People often ask, how do I choose my agent under my power of attorney? So for healthcare decisions, there are sort of two schools of thought about this. The first is you want to choose somebody who's going to make a decision that you believe, that they believe you would make if you could make it. And the other school of thought is, no, you want someone who's going to make a decision that they think is best for you. And to the extent that those overlap, to the extent that those decisions look the same, the better healthcare decision maker it is. So you would have people who consider quality of life in the same manner you do would be a good choice. People who think about end of life religious considerations regarding after death, that people who are able to make difficult decisions in a highly emotional time, people who can stand up to others, those are really good healthcare decision makers. Notice I didn't say proximity. That's lovely, of course, but not critical. Your financial decision makers really are the same types of people we talked about for personal representatives, people who are have high financial acuity, have shown responsible financial management. They are not, they don't have a history of bankruptcy and inability to manage their own finances. Powers of attorney can be effective immediately. So as soon as you sign them, you can act. I commonly recommend this. Families typically pool together in times of need, emergency, and stress, and having it effective immediately gives people the ability to get help when they may not need it for incapacity purposes, but it would be really nice. For example, people getting rehabilitative care in a long-term care setting may be able to have the capacity to make decisions, but could not effectuate those decisions. The alternative is what we call a springing power of attorney, which is effective when a physician says you're unable to manage your affairs. Sometimes it's hard to get that in times of stress and times of grief. So whether or not that hurdle is appropriate for you would be a decision you'd have to think about and talk with your advisor about. I think that about covers everything. So I gave you a little bit of levity. Estate planning is never that fun to talk about. Even I acknowledge that. So some things to sort of read and chew on and enjoy. I hope you've enjoyed the estate planning lecture, that you've learned something from it, that your questions have been answered. We're now going to move to the question and answer format for the program, and I have the lucky privilege to be joined by two distinguished gentlemen, and I'd like to tell you a little bit about them. So the first person is Bob Heck. He's a financial advisor and co-owner of Kylie Juergens Wealth Management, LLC. Excuse me, they are a local independent RIA and manage assets in around $2 billion for individuals, employer-sponsored retirement plans, and nonprofit organizations. He earned his BA and MBA from Willamette University in Salem, and from 2007 to 2011, he served as the Assistant Director of Annual Giving at Willamette. He holds the designation of Certified Financial Planner, and in this role, he holds himself to a high level of competency, ethics, and professionalism as a fiduciary and planner. He's a graduate of Leadership, Thurston County. Bob is a current board member and past chair of two organizations, the Olympia Hands-On Children's Museum and Willamette University Alumni Association. He is a former trustee of Willamette University. And of all of these sort of fancy credits and accolades, Bob asked me to share with you the most that he has deep roots in the world of nonprofit development. His first professional job even was at the University of Washington Tacoma's Office of Advancement. So he'll be joining us along with Scott Clays. And Scott currently serves as the Senior Director of Gift Planning for the Salvation Army's Northwest Division. He has over 25 years of fundraising experience, primarily in charitable estate planning. He has helped hundreds of individuals and families with different values and goal plans and goals for planning their estates. He's a volunteer board member of Leave 10, and I just learned also one of the originating members of Leave 10, so we have him to thank for that. He received his undergraduate degree in economics from the University of Puget Sound. He received his financial designation of Charter Advisors in Philanthropy from the American College. He completed his certified fundraising executive designation and fellow in charitable estate planning. So as you can see, we have very impressive people to join us today, and we're going to move to that portion.
Well, thank you, Lauren. That was just incredible. You did a marvelous job, and you can enjoy a glass of water and take a break here for a minute, because that was really, really well done. Great information, and I really enjoyed how you incorporated people's questions, because we are lucky to have lots and lots of great questions, and I really enjoyed having people share them ahead of time, so it allows to, combine those themes. I'm also glad Bob's here, and he's got a little nonprofit perspective. We've got a marvelous group, a great group. I think it started with nonprofits and some advisors. We also have some donors, and I know nonprofits have invited other staff members. And this is just such a great topic, because I think it's just can be really, really positive. And there's just so many misperceptions on this topic. And it's great that we can come together and see what a gift it is to plan. So I'm going to have Bob share a little of his perspective first from the financial planner, maybe share a little that everyone can know kind of your role and how you interact with donors, your clients, could be nonprofit donors, but just share a little of your perspective first.
Thanks, Scott. Lauren, great work, and it's nice to see everyone, and thanks for inviting me to be a part of this group today. I went through a list of attendees, and I see some familiar names as well. In my role as a financial advisor here in Olympia, I have a different perspective given my background in nonprofit fundraising and work with nonprofits. And in all of the pieces that I heard Lauren work through, I really want to call attention to the fact that we individuals, whether you're the donor, whether you're the soliciting gift officer, whether you're the attorney or a financial advisor or CPA, we all see a pretty clearly delineated slice of the donor's individual profile. And I love slices, I love pizza. We all of us will do a better job collectively the more pizza we see. So in that space, I know that I'm not an expert on the tax side. I know I'm not an expert on the legal side, but anytime we start to have estate planning conversations in my office, I'm always excited to ask and offer to coordinate, to talk with, and to lean on the expertise of the different professionals in my clients' lives. And I hope that that's something that's a big takeaway. I know that there were a lot of questions on individual details. You don't have to be an expert on any of those individual details. We've got a lot of resources with our own practice, but also in the community. And I think leaning on my friends at the Community Foundation here, but also the experts that we run across. And I have a really fun perspective of getting to talk to individuals about the wealth creation sometimes and more often, and then it gets to a point of transitioning to retirement and the question of how to use these resources. And sometimes there's charitable giving that happens in the course of a life, but not always is it a part of a discussion in terms of legacy planning and retirement planning. So it's something I oftentimes will bring up, and I think each of us has a responsibility on our shoulders just to ask the question and to look for ways in which the values of individuals can be better served with a little bit of planning. At the end of the day, I want to advocate very strongly for considering putting together at least a piece or two, if not everything Lauren has gone through. The clients I have who have estate plans have a much easier time getting everything organized and transitioned. It is not a question of if we will pass away. It's just a question of when. And far too often I've been in a situation to help when it had been either a gray area, muddled, or no estate planning whatsoever. And the work that a little bit of time will save individuals, especially those who are the surviving heirs and or family members, is just incredible. But also it's a process, and it doesn't have to happen all at once. It can be, you could take bites over a period of time. I think of clients I work with Lauren, and it's a process that maybe takes a day to start the idea, and then 3 years later, there's a totally different but complete estate plan, or sometimes it's 3 months. But in that sense, I encourage everyone, donors and any professionals alike, just to chew on what happens when you're not here, and how what you're doing today you'd like to carry forward.
That's great. And Bob, in your work, you probably get to meet more regularly with your clients, and you don't probably charge by the hour, so you really get a chance to get to know them and get a little deeper into their values. Is that fair?
Yeah, I think that's real accurate, and everyone comes at this differently, but it's regularly reviewing and talking to clients just to get to understand how they tick, and then where the financial goals are and where we are in the process. So that's a conversation we have almost daily. And when it comes to kind of the bigger picture items, I try and get to know clients and be as relational as possible, but also looking for ways in which I personally, as a professional, can educate myself on opportunities and tools that exist to help further the goals and individual values for each of the clients.
That's great. And I think the mission, or Leave 10, is really an effort for all of us, to talk about it, because attitudes change by people, talking to one another. And unfortunately, they don't leave Lauren's office and say, hey, I set a great estate plan together and I'm given to 5 charities. Unfortunately, I wish people would talk about it more, but that's kind of what Leave 10 can do, as a way to get people to talk about it, because it really is positive. It's about caring for the people that you love and making sure that they can celebrate your life and not, regret over it. And of course, the causes that are important to you. And there's a couple of things I see a lot, and I know a lot of nonprofits are here, and even hopefully some people who don't always ask for gifts or bring up this topic much. But I think we don't need to be afraid of it, because this is really about what's important to people. And anyway, that's what I think is just key. One thing I noticed, we don't have a CPA with us, but Lauren is pretty much a tax attorney too, so she can cover those questions. The one theme I think it's important for everyone to understand: a lot of people spend their time accumulating wealth, minimize tax wherever they can. They're very well of every little detail of what taxes, and that's how they spend their life. Yet they rarely think about their estate. Do they know how much, a tax is going to be on their family? And very, very few people think about it. And the reality, there's all these tax deductions for people when they're alive, but on the estate, you have a spousal, but that's really just a delay. And other than that, your only other deduction is the charitable deduction. And so when we talk about charitable estate planning, it's a big, big part of planning. And of course, here in Washington State, we have a pretty low estate deduction at 2.2 million. And even for people below that, the IRA asset, an individual retirement account, a traditional one, as soon as that goes to a non-spouse heir, they have to pay tax on it. And they used to be able to spread that out and stretch that over a lifetime, but that's taken away too. So that's a tool that pretty much everybody can think about planning, and everybody can think about making a gift. And of course, the easiest way is to just do a beneficiary designation on that IRA, because 100% of it will go to that charity or charities. And you don't even have to go to your attorney to update it. But I do, remind everyone, if you do that, please let the charity know. Now, all of us charities are more than happy to keep you anonymous, but not all of the financial custodians are required to contact a charity on these beneficiary designations. So it's really important, if they just know Bob Heck designated his account at ABC custodian, to go to Willamette College. If Willamette College doesn't know that, they might not be able to claim it. So anyway, we are here as nonprofits to serve our donors. And the more we bring up this conversation, the better, because I think the other theme I wanted to get out there too is endowments, and people's gifts are just so profound in the future of these nonprofits. And and really, I think if without endowments, a lot of these nonprofits aren't going to be here in a while. And so these legacy gifts are very, very profound. And I talk to a lot of people. I see a lot of people who don't have maybe direct heirs, and they really view the community as an heir. And so that legacy gift is very, very meaningful to them. And so talk to them about endowments and ways of that they can be remembered. And even people with kids and with family, that gift in your will, let's face it, Lauren does a wonderful job in drafting documents. But the most exciting thing is, in a lot of ways, is who the gifts are going to. And that tangible gift to a nonprofit is a permanent statement of their value. So it's very, very profound. So I just wanted to get that out from the nonprofit side. There was one question, maybe Lauren, you could talk to. There was a lot of question about cost, and I know most attorneys charge by the hour. Some will do a package deal, but maybe you could share what it would cost to do a will with some of the directives then compared to a revocable trust.
Yeah, I was trying to avoid that question a little bit.
Okay, well, you can go in general.
Well, just because it varies so very, very much,
Sure.
right? Depends on what market you're in. If you're in a place like Olympia or a place like Seattle, it depends on the model the attorney uses. Some attorneys use a flat fee model, which my office has chosen not to do. We have had a hard time finding a way to make that equitable to clients who, some of whom have very simple plans, some of whom have much more complicated plans. But other attorneys seem to have been able to nail that a little bit better. And I think clients like it because they know exactly what it's going to be. But I encourage you to not rule out people who are billing by the hour. They often will come in under those dollar numbers. I would encourage you for people to ask questions, not necessarily what is the hourly rate of the people who are doing the work, but questions around what is the average cost in your office for doing this work, because often more expensive attorneys have people who are bill at a lower level, who are an important part of that planning process to keep costs down. They are often efficient and have efficient tools because they've been doing it for a long time. So I think those are better questions to ask that when you're sort of price shopping. There are some online resources. I spoke a little bit with Scott before this. There's a wonderful, wonderful organization in town, and their website is WashingtonLawHelp.org. Washington all spelled out, help, HELP.org. They're probably here today. Their website is a vast, very, very rich source of information that is accurate, that is Washington specific. And also they have some sample powers of attorney and healthcare directives on that document that can be found for free. Online resources, free resources. I of course, because I don't think that they are the best document. I think they are, they are of course never consider the unique circumstances of the individual, but they are better than nothing usually. Sometimes we have to spend a lot of money to fix them. But for powers of attorney and healthcare directives, the online choices are probably pretty decent for most people. It's hard I hesitate to give an exact dollar number just because I think it will vary so much.
Yeah. Well, thank you for that.
Can I offer a little bit?
Yeah, go ahead, Bob.
It's a common question that I get in my office as well, and wanting to be sensitive to it. I think our firm is chosen to be a management fee firm, which puts us in that space of absolutely automatically being a fiduciary. I think, and I did see a number of questions around cost and components. There are a lot of ways to get through a project. And some folks that I run into are do-it-yourselfers and want a little bit of guidance, and we have one meeting, and they go away and they're super happy to do the work that I do. Other folks come into my office and they really don't want the responsibility or any of the pieces except to talk to me personally. I think it's a good reminder that every individual is going to be different, and we professionals are all here to play a role. And if we can be helpful, just being mindful of asking up front, hey, what is the fee structure? How are you compensated? Is a great question. And on the other side of it, it can be a really valuable add to anybody's overall financial planning or estate planning, but everyone's going to be different. So there are resources on the do-it-yourself end, and then there are folks who roll up their sleeves and get more involved. And how lucky are we to have all of those options out there?
And I think the other thing to consider, and I want to give credit for that website to the Northwest Justice Project. They deserve that credit, and I realize I didn't say their name. But the other thing to consider is, yes, it's about the expense you're paying now, but there is a huge cost savings later for your family, right? If we can put tools in place that are automatic, you may have some expense to that now, but it may save a lot of money, and I mean a lot of money, right, in taxes, in just cost of administration. So I think it's mindful to be aware of the total cost to the family, not just the cost of the planning.
Yeah, well said. And I'm also happy if people have questions, because Salvation Army, we work everywhere. So, and Thurston Pierce, I know we have some people up in Jefferson County. And we keep a list. Of course, I can't offer you legal advice. We do know people like Lauren, though, who are knowledgeable in the field, and people like Lauren will give you, they'll quote the fee right ahead. And again, there's different attorneys. Not everyone needs a tax attorney. Oftentimes people may need more elder law, more, long-term care. So based on what your goals are, we can, probably direct you to some good resources as well. And I'm also happy to help you and point you to directions of online information, because there is a lot of information. Some of the law schools will offer legal advice. I know at Gonzaga, I'm not sure Seattle U does, but there are some resources. They do, good.
Or at least they did when I was there.
Oh, good. I was going to say, yeah. So there's some good resources there. On the online tools, I agree, something is better than nothing. And again, a lot depends on your situation. I have a lot of people who don't even have a computer. So, the online resources don't work. And that's where the legal services at Gonzaga have helped. But again, it just depends on your situation. And I know a lot of the online ones don't even have a legal review. And the other caution is they don't cover the deeding, they don't cover the titling. There's a lot of things covered in beneficiary designations that just aren't addressed there. So they're a great source of information, but again, depending on your situation, that investment in sound legal advice is 100% worth it, I would say.
I did recently ask ChatGPT to do a Washington power of attorney and see how it was. And I gave it about a solid B minus-ish, but it'd be better than having nothing. And, that's fine.
There was another question about if people have a will that's out of date, or maybe they created a will out of state. What would you recommend, Lauren? Maybe they moved here from a different state. What would you recommend? How would you answer them?
So I think so the best action is to have that reviewed by an attorney here in Washington. For one, our tax structure, our tax exemptions are so much lower than other states that if you have assets that exceed $2 million, you may not have any planning for that in a document from another state, but would absolutely need it here in Washington. There are some documents that we need specific language to be included in the document to be able to give powers, like under powers of attorney. We absolutely will admit what we call foreign wills from other states in the United States as valid wills. They may just not be the best choice for you. So even for snowbirds, we often recommend, at least for the powers of attorney, to have them reviewed by an attorney in both states to make sure that they offer the best, the best protection and best grants of authority that both states can offer. But if you haven't done it, it'll work better than nothing, right? But I really advise people to get them looked at and review. Not only make sure that the statutory changes don't need to be implemented, but that your wishes and goals, if you've done something as large as a major move.
Mhm.
Scott,
There was,
can I add one piece on that
yeah,
as
go
well?
ahead. Mhm.
I'd be remiss if we got through this without calling out beneficiary designations. I know that we've mentioned it a little bit. In my world, I deal a lot with retirement accounts, both individual and employer retirement accounts. And the horror story is someone does not change a beneficiary update when their life changes. And so as we're talking about getting things reviewed, my advice and our firm always encourages folks every 1 to 2 years, look at all your benefits and just take a peek at those beneficiaries and make sure that the names listed are the actual beneficiaries that currently you would like to receive something.
Yeah, and
Well said.
I think it can't be understated the importance of retirement beneficiary designations in our charitable planned giving. When you leave assets in a will or a trust, those assets typically are best served if they do not trigger an income tax consequence. But in a retirement account, Scott mentioned it, your beneficiaries have to pay income taxes on it. And now for non-spousal beneficiaries, it's compressed to 10 years. That's a really significant income tax hit where a charitable entity doesn't have to pay income taxes on it. So it is really a powerful planning tool to think about satisfying those bequests in your retirement accounts, modifying percentages or bequests that you might have done in a will while prioritizing those bequests in a different manner. You have to look at them as the retirement accounts change in value over time. But the end result is that everybody gets more money, right? The organizations and your family. So it's a really simple tweak in a plan that has your beneficiaries getting more while still honoring your commitment to the organizations you care about.
So a real big thank you to everybody, and a special thank you to Lauren Pitman. We're coming to the end of our, excuse me, our time here. What a wonderful gift, Lauren, you've given to everybody today. And thanks also to our panelists, Scott Clays, Bob Heck, and of course, excuse me, just a second here.
We took your voice, Rick.
Well, you've taken my money, now you've got my voice. No. But anyway, thanks for them. Let's show a little appreciation with some air applause, everybody.
Thank you.
That was
everybody.
great, and you guys did a wonderful job. So thank you for joining us. Excuse me. Leaf 10 South Sound does not fundraise. We support all nonprofits with an interest in planned giving, and we offer supportive information and education to nonprofits and professional advisors who want to increase their knowledge and ability to assist clients and donors in reaching whatever the donor's philanthropic goals may be. There is a complete section on the Leave 10 website to assist donors as well. There's 3 tabs there, one for nonprofits, one for professional advisors, and one for donors. All of the materials, educational offerings, and online toolkits are offered at no cost on our website. And all of our expenses right now are being covered by the generous support of our sustaining partners, Greater Tacoma Community Foundation, the Community Foundation of South Puget Sound based in Olympia, and the Ben B. Cheney Foundation. We are grateful for these local foundations who believe strongly in what we are doing. Access to our website is simple. Just type in Leave 10 South Sound into your favorite web browser. The site has general information on the landing page, and again, those 3 tabs that I talked about, one for donors, nonprofits, and professional advisors. When you get the bug, and we hope you do, and want to officially join our initiative, go to the section on champions and sign up to be a Leave 10 champion. Then talk about this initiative with family and friends. And when you become a champion, believe me, you'll be in good company. Just take a look at the list of people that are already there. Leave 10 South Sound challenges your thinking with the word imagine. Imagine how South Sound communities could be positively impacted by completing this one act of generosity. Just leave 10% behind to invest back into the communities that made us who we are. If you still have questions, our professional advisors can stay for a little while, maybe. I don't know if more have come into chat. On behalf of the Outreach Committee of Leave 10 South Sound, thank you for attending and have a great finish to your week.
Thank you.
Thanks,
Thanks,
Rick. Thanks, Genevieve,
Thanks,
everybody.
Scott. Thanks, Lauren.
Thanks
Yeah.
all.
I am able to stick around for a little while if people
Okay.
have some more questions that they'd like to see answered. I don't know about the other panelists.
Well, we still have about 80 people on. There was
Hi.
one that went into chat, and that is, our trusts in Washington afforded more privacy than a will.
Oh, what a great question. It depends on how you define privacy. So what I mean by that is it is true that a trust does not have to be filed with the court. Therefore, it's not necessarily available on the public docket, but you still have to provide notice to, again, the people who would be your legal heirs and the people who are also beneficiaries. So and in fact, when we create some trust, we have a duty of accounting to some of those people that doesn't exist with a will. So if the goal is to try to keep your information more private from other members of the family, maybe that might provide some protection. We might be able to avoid giving notice to some people, and we don't have to do the court filing. So but we try not to leave super private information in wills for that purpose. But I think the answer to that is, yeah, maybe a little bit.
Genevieve, any other questions that you can see?
Yeah, so I don't know if y'all can see them. I'm happy to read through, but we do have a lovely question answer tab. I will pull some, but I also just like to check to see if you can see it because I am new to learning this as well. So I might not know which are the best questions. I did see one that I thought could be interesting from a nonprofit perspective and an individual perspective. That was, I believe most nonprofits want specific language specific designations. So should we ask for that language when designating in our wills?
You mean the nonprofit ask for that language? I think
The donor.
The donor.
Yeah.
yes. I think all nonprofits should have that language readily available. And absolutely donors should contact the charities.
Yeah, and I liked your point too, that charities are more than happy to keep everything anonymous if that's what the donor requests. So.
And conversations, I think, also about what you're giving to the organization. They may not want your whatever it is, a certain kind of stock or a certain kind of real property, are important conversations, and also whether you plan to restrict the gift for particular uses or whether it is an unrestricted gift.
And on the organization side, I'm thinking of a couple years ago, Lauren and I and some other really committed folks helped draft a gift acceptance policy and update some policies for the Hands-On Children Museum here in Olympia. So on the organization side, thinking through and being okay, saying yes, we want this stuff, and no, we don't want to touch this stuff because it's just not worth time and energy. But being able to give yourselves that permission as an organization, so that then you can effectively communicate with donors when they ask.
And I believe if you're a smaller nonprofit and that topic is a little intimidating, the toolkit for nonprofits has some information and some resources about gift acceptance policies, because you want it to be flexible in general. But if you have questions, I'm happy to answer too.
Yeah, and one of the other things, so let's just say that you're a small college and you are trying to redo your gift acceptance policy. I know most universities and colleges will share their versions with you if you ask for it, because we're all here trying to do exactly the same thing. We're trying to do what the donor wants, what the client, within the client's best interests, and fulfill the things and the obligations that the institution has as well to the community. So.
You know, when you were talking about wills and trust, one of the costs associated with the trust that is pretty high in Washington, just the filing fee of changing the deed is $325. And that does not count the cost to do the quitclaim deed. So it's essential, I think, if you have out-of-state property. But anyway, that's something I share with people too.
Yep, that's why I say it's more costly to sort of create and fund. Yeah, absolutely. The funding process can be expensive. And then we have to take it out. later.
Yeah.
Either because you've sold it, or we're doing a new asset, or when you pass away.
Mhm.
Well, we still have 56 people hanging on here listening to your every word. If Genevieve, any other questions in there that you think might be of general interest?
So we do have some questions. We have some specific legal ones that may have already been addressed again. So I can pop some of those in the chat maybe, and then have you all look over it. I can also, this is a quick one, and then Lauren, or any of you can let me know if maybe this is not an appropriate question, or at least may have already been answered. Can you suggest who could be a witness for the will? If someone does not want friends or relatives to witness, for example.
Yeah, and just so you know, Genevieve, at least I can't see the question, so I'm gonna have
Great.
to rely on you.
Okay, I'll be reading
Yeah,
them.
so anybody, I mean, truly anybody. We prefer not people who are interested parties. We prefer people who are not either inheriting from you or providing caregiving for you. If you have to use an interested party, it's not ideal, but you can. But they have to be over the age of 18. They have to have capacity to be able to witness that. But really, other than that, there are no restrictions on who could or could not be a witness. There are restrictions about who can serve as fiduciaries. Personal representatives can't be felons or had convictions for, lie, stealing, or cheating. But really, almost anybody who is an adult is good to go.
Great. I have another one coming in. What is the maxed gift to children per year?
So again, the annual gift tax exemption right now is $18,000. That's a federal limit. If you go over that number, it's okay. You just have to tell the IRS on an IRS Form 709. That will reduce your lifetime gift and estate tax exemption at the federal level. Washington doesn't have a gift tax at all, so it's really a powerful tool here in Washington. But unless your estate is over that really high estate exemption number, which again right now is 13.6 million, although it is set to go down absent legislative change, it is a reporting document only to the IRS. It doesn't actually create a tax obligation. So if you are under that number or married and under double that number and you want to leave or give $200,000 to your kids, that's wonderful for you, wonderful for them. You just have to tell the IRS because it's over 18. Now you can give 18 to any individual. So if you are, any one person can do that to any individual. So if you are a married couple, you and your spouse can gift to that individual or to their spouse, 18 each.
Okay, I have another one. How do you recommend a charity foundation seek out an estate gift when the donor never shared their will or letter of intent before they passed, but shared their intent verbally or via email?
Yeah.
I mean, I can make some suggestions for how to find a will that you don't know about or might exist. We regularly get emails from our county bar association with inquiries about if anybody has a copy or information about a particular person's will. So we can, you can inquire in that way through local bar associations. Beyond that, I can't speak to the other parts.
Thank you so much. Let me comb
Well,
through
there
here.
was, I think, a question earlier too. I mean, a lot of people, who needs to know about the will? Because a lot of people think, oh, well, the attorney knows about the will, but it's really the PR, right, Laura?
Yeah. And knows how to get to it, where it is,
Exactly.
and how to get to it, right? If it's in a safe deposit box and they don't have authority to get into that box, we can't get to that box without getting a court order, which of course adds expense. So if you're going to put in a safe deposit box, they have to be named on it. They do not need to be on your account. If you're going to have it in your safe at home, someone needs to know how to get into that safe at home. And then just so as sort of common tips, my advice around powers of attorney and healthcare directives are that those are actually given to the agents because you do not need your own power of attorney, but your agent would. I also don't like giving healthcare directives to healthcare institutions. I'm sure the healthcare organizations on here are cringing. I believe that is a tool in the toolbox of the agent on the power of attorney and should be part of what's available to them.
And the original will is what's needed by the probate court too. So those instructions of where the original, because we as a nonprofit have had copies, but again, there was a delay because we didn't know where the original was.
And without that, you're often forced to go intestate, absent evidence that it was unintentionally destroyed, like a flood or a fire. And then those charitable organizations or whoever you want would be out, absent family agreement.
Well, I'm reluctant to do this, but I'm going to call this session to a close. Thank you so much, all of you, Lauren, Scott, Bob, Genevieve for being our captain in the background. You did a wonderful job, and we still have 49 people listening to our goodbye, our swan song here. But thank you all for attending, those who are still here and weathering the storm with us and the coughing fits and all of that. Anyway, have a great day, and thanks again for coming.
Take care,
Thanks,
everybody.
everyone. Good to be here.
Thanks all. I will be sending out a recording to you all. So if you want to watch it again or you have any questions, just feel free to reach out to me, but I will be following up.
Perfect.
Thank you.
Thank you.